Mahkamah bangun. Mahkamah kini bersidang. Ya Arif, di dalam Mahkamah Tinggi di Shah Alam, ini adalah kes rayuan Muhammad Syahril lawan Pendakwa Raya. Kes nombor BA 42 CY 103-2024. Ini merupakan rayuan terhadap keputusan Mahkamah Seksyen Kajang di bawah Seksyen 233 Akta Komunikasi dan Multimedia 1998. Ya Arif, izinkan saya perkenalkan diri. Saya Nur Amrah Safia binti Kamal di pihak pendakwaan. Bagi pihak pembelaan, Tengku Aliul.
Saya Tengku Aliul Mutato. Ya Arif, mewakili Muhammad Syahril.
Dengan izin Ya Arif, Puan Hakim, saya memohon untuk mengendalikan perujahan ini dalam bahasa Inggeris.
Okay, boleh proceed when you are ready.
Your Honor, on July 26, 2020, my client posted a live video questioning PDRM lack of action on a criminal breach of trust report. We submit that Section 233 of the CMA is unconstitutional as it is repulsive to Article 10 of the Federal Constitution.
Counsel, based on the record, the accused was charged with making statements that were allegedly offensive and intended to create annoyance. Defense dispute all of these elements?
Yes, Your Honor. However, we raised three arguments against the prosecution. Firstly, is regarding the offensive test. We contend that the court below has made an error by applying a subjective standard. The determination of whether a communication is offensive under Section 233 must be based on an objective test. Specifically, what a reasonable person in our diverse society would find as offensive, rather than relying on the subjective feeling of annoyance experienced by a particular individual or complainant. Second, we challenge the interpretation of the word person within the context of the charge. It is our submission that Section 233 is intended to protect a natural person. The Royal Malaysia Police, as a state institution, does not fall within this definition, and therefore the charge as framed is fundamentally defective. Finally, we also raise a significant constitutional challenge. We submit that Section 233 of the CMA is unconstitutional as it unjustifiably restrict the fundamental right to freedom of speech and expression guaranteed under Article 10 of the FC. By criminalizing annoyance, this provision is overly broad and creates a dangerous chilling effect that discourages citizens from engaging in a public discourse and criticism of authorities.
So, how does the defense define a reasonable person within the Malaysian context?
Your Honor, it refers to a reasonable person of society who is fair-minded and not overly sensitive, taking into account Malaysia's multicultural society.
So, the defense is suggesting that local institutions are not entitled to protection under this supervision.
No, Your Honor. Our submission is that the provision was never intended to extend to a state body.
So, DPP, your response?
Ya Arif, the conviction is safe. Firstly, on the issue of factual falsity, Ya Arif, the appellant's statement were clearly untrue. Evidence before the court shows that the Royalty Malaysian Police PDRM had already opened an investigation file marked as P14 on the very day the report was launched. Therefore, the allegation that the police had failed to act is baseless and misleading. Such statements were not only inaccurate but had the tendency to tarnish the reputation of the authorities. Secondly, on the definition of the term person, the defense argues that persons refers only to natural persons. However, this interpretation is incorrect. Under Section 3 of the Interpretation Act 1948 and 1967, the term person expressly includes any body of persons, whether corporate or unincorporated. As such, Ya Arif, PRM clearly falls between this definition and is entitled to protection under Section 233 of the Communications and Multimedia Act. Thirdly, on the constitutional argument regarding Article 10, while it is true that freedom of speech is guaranteed under the Federal Constitution, it is well established that this right is not absolute. Article 10 Clause 2 expressly allows Parliament to impose restriction in the interest of public order, morality and security. In this case, Ya Arif, Section 233 serves as a necessary safeguard to prevent the misuse of communication network for the purpose of spreading false and harmful statements. In conclusion, the prosecution submits that all elements of the offence have been proven beyond reasonable doubt and the conviction should be upheld.
So, does the prosecution say that these statements could undermine the public confidence in our government bodies?
Precisely, Arif. False allegations have the tendency to erode public trust and create unnecessary alarm.
So, Counsel, do you wish to reply on this issue of proportionality?
Yes, Your Honor. Any restriction must be proportionate, as Section 233 is too vague and broad.
So, DPP, how is the prosecution going to prove that this is an intent to annoy rather than an intent to criticize?
Ya Arif, by the nature of the false accusations that were made publicly, Ya Arif, the statements were not merely critical but were false and capable of causing annoyance and disturbance.
Alright, so the court will be adjourned for 30 minutes for me to deliberate this case. Alright, so the court will be adjourned for 30 minutes for me to deliberate this case. The court is adjourned. Alright, so having carefully considered that the submissions of both parties and applicable law, the court makes the following findings. First, the court finds that the Royal Malaysia Police falls within the definition of person under the law. Secondly, although Article 10 of the Federal Constitution guarantees a freedom of speech, such right is not absolute and it is subject to lawful restrictions. The court agrees that Section 233 of the CMA 1998 constitutes a valid and constitutional restriction. Lastly, the appellant has failed to establish that the provision is repugnant to the Federal Constitution, and accordingly the appeal is dismissed and the conviction and sentence of the lower court are hereby affirmed. Court is adjourned.